It's an enigma, a mystery.
And I don't like mysteries.
Cipher wrapped in an enigma, smothered in secret sauce.
The motor vehicle division can be a bit of a mystery at times. And when a person is charged with DUI, well, things only get more complicated. When a person gets arrested for DUI, it starts two cases in two different places. The motor vehicle division case starts when a person is given what's called an admin per se implied consent affidavit. Admin per se refers to when a person consents to an officer's request to perform a chemical test. If, for example, the officer requests you take a breath test and the result is above a .08, that'll trigger a 90-day suspension. For the first 30 days, there's no driving. However, most people are eligible for a restricted permit to and from work, to and from school, or to and from the doctor for the remaining 60 days. An implied consent suspension results when a person does not consent to a chemical test and an officer has reasonable grounds to believe the crime of DUI was committed. If the officer then has to get a warrant, the consequence will be you will be suspended for 1 year. Now, you may be eligible for a restricted driving permit after the first 3 months. The restricted permit, however, will require that you get an interlock device installed in your car for those 9 months. So in review, once a person's arrested for DUI, you've got the court case and the case of the Department of Motor Vehicles. If you refuse the test, they're going to call it an implied consent suspension. If you consent to the test, they're going to call it an admin per se suspension. The question then becomes, do you request a hearing or not? If you request a hearing, the suspension is stayed. That is, it doesn't go into effect until at least the time of the hearing. However, if you do nothing, the suspension will automatically take effect 15 days after you were served with the admin per se implied consent affidavit. If you win your hearing, there's no suspension. If you lose your admin per se, you get a 90-day suspension, but remember you get the 60-day restricted permit. If you lose your implied consent, you still can get, after the first 3 months, a 9-month restricted permit. Even after the hearing, we still have some concerns with our driver's license. In the court case, there'll be things like an arraignment, pretrial conferences, motions, and eventually it will resolve by either a plea agreement or a trial. The result of the criminal case can also affect your driver's license. If you're not convicted, we don't have to worry. However, if you're convicted, the court will notify the Department of Motor Vehicles of the conviction. If you won your MVD hearing, now you're going to have to do that 3-month suspension. You're going to have to go to traffic survival school and also install an ignition interlock. If you've already done your admin per se suspension, you do not have to do another suspension. You just have to be careful that you don't get enough points to trigger some type of point suspension. You'll also have to go to traffic survival school and get an interlock. Similarly, if you're already facing a 1-year suspension because you lost your MVD hearing, getting a DUI conviction will not cause an additional suspension. However, there is an additional ignition interlock requirement. That is, in addition to the 9 months you did on an interlock to get the restricted permit, you'll have to do an additional term solely because you were convicted of DUI. Hopefully this has removed some of the mystery, untangled some of the enigmas, and cleared away a lot of that secret sauce when it comes to a DUI in your driver's license.